It's not just the charge, but it's where the charge operates that we find so central, that they're two different things. There's two different
problems. Is it clear that
problems.
the charges against your client could not be amended?
They may be amended. Yes.
Then why should why should there be review before trial of a charge that could be amended? There could be additional charges added by the time there's a final decision.
And Justice Alito, the government has had essentially now 4 years to get their charges together on Mr. Hamdan. At this point, what you have before you is the charge, and they've stuck with this charge of conspiracy, which is not a violation of the laws of war, and indeed it's not just conspiracy isn't, but that the commission is operating in totally uncharted waters because it's charging a violation in a stateless, territorial-less conflict.
The 1949 Geneva Conventions were being negotiated contemporaneously with this Court's decision in Eisentrager. And even if you think the rule is different today, at that point, Justice Jackson was quite correct that the idea that an enemy combatant would get access to the domestic courts of a detaining power was absolutely absurd. And so what the framers of the Geneva Convention recognized that they were dealing with a group of people that were uniquely vulnerable, so they went to great pains to make sure there were mechanisms to enforce their rights.
He's too much of a klutz.
Well, certainly the DTA was a large portion of the discussion. I'm to say that there are some men who don't have the right to be present in their trial. To say that there are some men who don't have the right to confront the evidence against them. There are some men who can be tried in a tribunal where the rules change every day. And if he wins a ruling, tomorrow he can lose it. If we say those things, then where are we? What are we saying to the world?
Just with me and